Hi, my name is Natalia and I am a real estate attorney here in the state of Florida. And today I wanted to talk to you about title issues that come up if you have estranged spouses. So let's say your marriage did not work out, but you haven't had the time, the money, the energy, whatever reason it might be, to file for dissolution and to get that final judgment of dissolution. But you own property with your spouse, or you acquired property during the marriage, even though you're the only person entitled. Well, you might find difficulty in selling that property or refinancing that property if certain factors come into play. So, step one, did you and your ex-spouse, who is not officially your ex-spouse, actually live in that place as your primary place of residence? Are you still living there as your primary residence? Are they living there as their primary residence? Even if you're the only person on title, they are going to have to execute that sales contract, that refinance agreement, that deed of conveyance. And if you are having a difficult time contacting that person or getting them to agree to anything, then you should probably talk to a family law attorney about getting everything in place with a final dissolution of marriage so that you can get things done to sell that property. Otherwise, there's going to be major title issues involved. The same thing comes down to, let's say you're separated, but in Florida, there's no official separation. You're either married or not married. And so you want to buy your own place and you want to mortgage out your own place. Well, guess what? This place is going to be your primary residence. That ex-spouse is going to have to execute the mortgage and acknowledge a few other forms where they're affirming that, yes, they're still your spouse, that yes, they understand, it's called a compliance agreement, that they may have to re-execute the mortgage if there was an error on it. They're going to have to execute the mortgage because they have to acknowledge that there is a debt upon primary residence of the marriage, and a lot of annoying issues can ensue as a result. And then another issue that you might have is, let's say you filed for final judgment of dissolution. You've got a final judgment of dissolution, and you all forgot to address the property. So now anything that you owned jointly with your husband at the time is going to be owned as tenants in common, meaning if that spouse passes away, you're going to have to deal with their heirs. If you want to sell the property, you're going to have to come to an agreement to sell the property. So be aware, be mindful of those things, and take the time to go speak to a family law attorney if you see issues coming up and if you own real estate. The same thing comes to you investors that are approaching individuals that appear to be in desperate need to get rid of property and say, they talk about their ex-husband, ex-spouse, or something like that. Make sure to ask if they do have a final dissolution of marriage, because that wholesale agreement is not going to be very useful if you only have one of the spouses signing on to that wholesale contract, particularly if that is the primary residence of either one of them. So issues I wanted to make you aware of, things to keep in mind so that when anybody talks about their ex-spouse, ex-wife, and are trying to convey or refinance a piece of property, you might want to be very clear about where they stand and if they're legally married or not. Good luck out there, investors.